Ready? You're on mute, Ari.
Oh, I'm going to go to gallery view.
All right, we're live.
Okay, we're live, so let's stand for the pledge.
Okay.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
As a way of respecting, honoring, and creating awareness about our past, we begin our village board meetings by acknowledging that New Paltz is on the ancestral land of the Munsee, Esopus, and Lenape people.
Okay, so there's nothing to change or amend regarding this agenda, right, Ari?
Nope.
Everything that's here was here. Okay, I motion that so we don't have to motion to approve the agenda, right?
Yeah, you do. I think
Okay,
you
I motion that we approve the agenda. I thought we only did that if it was to be amended.
No, you do it every meeting.
Second.
All in favor, aye.
Aye.
Any opposed? Okay.
Nay.
And so there's no consent agenda here. And then what we're going to do, if anyone, and since we're all trying to figure this out as we go, wait, is this live on YouTube?
I'm getting a little button in the upper left that says in big letters live.
Yeah, I see it. Regarding this agenda, right?
Yes, we are live on YouTube.
Great. So anyone watching on YouTube who wants to make a comment should do so in the YouTube comments. And I think we could even encourage folks to go ahead and leave comments as we go, and maybe we can just return to them later in the evening as we're all still figuring this out, as opposed to having a dedicated time where we're only considering public comment. Like let's essentially leave public comment open the whole meeting long, and then we'll see if folks have anything to share. Any announcements that we want to make?
Do the census if you haven't done it yet. I'll put the link in the YouTube comment section.
Cool. I second Alex's announcement to complete the census form. I also have a really important announcement. So today we had a sewer backup on Main Street in front of Karma Road and Water Street Market. And this is our third sewer backup during COVID. And what is going on is sewer mains are being clogged with disinfectant wipes and paper towels. So it's fantastic that people are being careful and wiping things down, but those materials cannot go into our sewer system. They create huge problems at our wastewater treatment plant, and they're creating huge problems in our sewer mains. So, this is escalated to the point where, we're spending a lot of money. To me, it feels like COVID related sewer problems. Maybe we can see if there's FEMA assistance to help us pay for, these types of situations. But, I just left the site on Main Street, and, our full staff was there. We have a temporary pump online now to go around where this collapsed sewer pipe is that, collapsed because of pressure with all the wipes and paper towels that jammed up inside of it. So tomorrow we're going to be opening up the street on Main and seeing how much damage we're actually going to need to replace and repair. But third COVID-related fatberg. So FATBERG. That's what happens when those materials are put into the sewer system and they're not supposed to be. They create blockages that compromise our conveyance system. So maybe we can do a little more public outreach regarding why it's incredibly important not to stuff stuff down the toilets or that should not be there. Any other announcements?
Speaking of COVID, people can continue to look at our website to get information as it comes. It's been not as much information as of late. This past week, a lot of it has been about the 3,000 masks that we have to distribute in our community. And we started that last weekend and we're gonna continue to do that. So you can actually pick up masks at the police department anytime, 24/7. If you need masks, you can go there. There's also times for Family of New Paltz, and we have also had the police distributing them when they're out on their patrols as well. So be on the lookout for more information about where we'll be out and about doing that again soon. Other COVID related stuff, I'm trying to think if there's anything else. Alex, anything? I mean, I would say the details about the reopening will be forthcoming. We know that they're coming. We do have, we were just talking before the call started whether or not we had started plateauing or not. And we do have a good amount of time before we would get to 14 days, which is how many days we need to get to in order to get to the stage of the first stage of reopening. So we have a ways to go, and we're going to be talking about what it's going to look like. I guess I can say, guys, I can say we've been talking about having an event, a virtual event at some point in the next couple of weeks to talk to the community about expectations for reopening. What are your questions? We have a lot of questions ourselves and await guidance from the state, but it's important for us to also hear from the rest of you what issues are important and what you're thinking about. So stay tuned for details for some kind of virtual event like that soon. I think that's it.
That sounds about it.
Okay. So do we have any public comments yet? I know we have some previously submitted public comments. Does someone want to share what those comments were, and then we'll probably just move into having a conversation about those comments. Does anyone want to volunteer to click on them and summarize or read the comment in whole?
Don't mind doing that, Tim, if it helps.
Yeah, great, Tom. So I know we got a comment from John Oleski. He's the chair of our planning board.
Yeah.
It was there was a lot to that comment. Do you want to go ahead and address, or maybe just summarize or read John's comment, and then we can address it during the rest of our program?
Sure. Yeah, that's fine. Reading it might take quite a while because it is a pretty lengthy comment, but I also want to do justice to the points that he's raising. So I think maybe what I'll do is a deep summary. If that's okay. I think people know that John's the chair of the planning board, so his comments are important in this process, and they're important to me. Would say, just to kind of preface it, is when the legislation that you have and have had for a couple of meetings was drafted, Eve was the chair of the planning board, so we were working with her, and nothing, I don't think anything changed in the language since that period. Specifically, most of this got drafted and talked about in July of last year. So John's come on since Eve left, but his comments came in today at about 5:26. I've had a chance to read them, but I think everybody can appreciate, not necessarily processed every nuance of them. He thanks the village board for your efforts in improving the processes for property development and improvement within the village. And he appreciates, I guess I could say, the comments by the HPC concerning applications for approvals that come before the planning board. So I guess I would just gloss onto that, but that was one of the central intents here, is to take some pressure off the planning board so that things having to do with architectural preservation don't have to be on the docket or only on the docket of the planning board, because they have so many other things to think about that we have never had to get into. I'm talking about things like traffic studies and things of that nature. Then John goes on to offer, let's just see, 3 major points. The first one is a single paragraph. I do not believe that the village can legally de facto declare the entire village to be a historic district, subjecting all properties in the village to the powers of General Municipal Law 96A. That, everybody, is the sort of underlying legislation that permits communities to use zoning or historic preservation to regulate growth or building in their department. Despite making no specific findings of historical significance to any particular district or structure and depriving landowners of the procedural safeguards available to owners whose property are actually designated as landmarks or part of a district. He goes on to say that his understanding is that it's never been tried in New York, but has been tried and found illegal under very similar enabling laws in Michigan and Washington state. And he's fearful that we could have a challenge if a certificate of appropriateness should be denied. I guess I'll just, if you're sort of taking notes or thinking as I'm going, it was Will Frank's opinion that we do have justification under 96A. We can certainly get back to that. I don't profess to know whether Will's opinion is correct or universally held, but that's the first objection, that in effect, we'd be declaring a de facto historic district across the village. Number 2, I do not believe that the village board has statutory power under New York village law to require a supermajority by the planning board to proceed with a site plan or subdivision approval. I'm not sure I understand this objection, and I believe John said that he would be listening, so if there's a way to communicate that, that would be great. What we were using supermajority to accomplish was to create a situation where we would safeguard against an overaggressive HPC in the future. A commission that, in the opinion of the planning board, opinion of a supermajority of the planning board, is acting too aggressively on the question of historic preservation. So that was the intent. Once again, Will Frank suggested this, and I think through his suggestion implied that it was legal. I don't know if I have a position or even a full understanding of John's objection on point number 2. Point number 3 is 3 paragraphs long, and I think is definitely something that we should talk about tonight. his point begins, the scope of the power granted to HPC is pretty vast, and notwithstanding the no fee provision, the application process itself is likely an unconstitutional burden, at least in some respects. For example, it appears that under the revision, any property owner would need to apply for and get approval to hang a US flag from a new flagpole attached to a porch. He gives some examples. On the second point, HPC, he fears, would have unfettered discretion to decide whether someone's proposed fence would, quote, have a substantial adverse effect, and that quotation is from the language that we've been using, on the, quote, aesthetics of their own property. Policy-wise, he says this has the potential to become a serious problem in the hands of a hypothetical future HPC that might be unconcerned with economic justice, which could deny applications for workaday fencing needed by middle-class folk who need to protect their animals and only approve expensive, quote, attractive fencing. And then the third point is how we would decide whether a resident's proposed garage mural or permanent political sign is aesthetically pleasing, aesthetically between quotation marks. Is the village board really ready for the consequences of telling every property owner that changing the color or design of their front door, or adding walkway lighting, or replacing old 4-pane windows with modern 2-pane windows requires an application and up to 62-day waiting period for HPC consideration before the work can commence? So I would sort of characterize these as a constitutional question about burden and the power of the HPC, unfettered discretion on things like fencing, and then thirdly, maybe a concern around delay as the certificate of appropriateness process works its way through. He closes by saying, I'm certain that HPC members and the board are looking for solutions, not problems here. And it may be that some of these have already been thought of and vetted by the village attorneys and that he's behind the curve. In any event, I'd be happy to get more involved and to bring the planning board into the process and gain other members' input to the questions that he's posing. And he says he'll be watching the live stream. So I'd be glad to clarify anything if anybody needs it, but that's, I think, a pretty decent summary of the comments.
I just sent John the Zoom link, so maybe he will join us.
That would be great.
Yeah,
I think that would probably be the most helpful. If it's okay, I might just make some comments on a couple of the points. And I really am taking these very seriously. I mean, I think obviously John's position on the planning board means we ought to be listening to him, but also the questions that he's asking are important ones. I do not know on the first point about the legality of a de facto entire village. I think that's a question for Will Frank. I'm not sure that in effect what we're having is a kind of minimal architectural review. So I'm not sure it's the same thing as declaring a de facto village-wide historic district. So I don't know if Will would clear that up. My understanding is that we have a pretty clear underlying right under Municipal Law 96A for communities to do something along these lines. The nuances are less clear to me. As for number 2, I think the supermajority vote, as I said, was really there just to safeguard against an overzealous HPC of the future. And basically what it does is vests the planning board with power to overrule a determination by the HPC if a supermajority, which we always construed as majority plus one in this case, feels that they're out of line. And I think that that is a good safeguard because nobody can predict what HPCs of the future might operate under. And then I guess the last thing I wanted to say regarding John's third point, which really has three parts, is I think there's a little bit of general confusion around what the HPC actually has purview over. So hanging a flag would not be one of them. The example that he's using about a flagpole is not a significant architectural change. I can't think of anything in almost 20 years of being on the HPC that would come close to something that minor that came before us. The substantial adverse effect is a pretty significant thing to be talking about tonight, because what those words were pretty carefully chosen when we were drafting this. There's not a single standard the HPC is aiming toward, and instead we're sort of thinking about this as minimal acceptable. And so this term, having a substantial adverse effect, really sets, in the world of HPC, a pretty low bar that something has to be actually detrimental to the community or to the neighborhood rather than proactively historically accurate or improved upon it. So I think we can have a profitable discussion about that. And then maybe the last thing I'll say about John's comments is we hardly ever talk about aesthetics in the HPC process because abstract aesthetics are very subjective, like pretty houses and ugly houses that's a very, very subjective thing. But what we're tasked with is historical accuracy or historical integrity. And so the measure that we use is not pretty or ugly or aesthetically pleasing or unpleasing, but consistent with the patterns and the conventions that other structures have in the community around that architectural style. And I just wanted to say, in all the time that I've been on the commission and every meeting that everybody participating tonight has been in, we rarely even use the word aesthetic. It's just not fundamentally in the vocabulary. I mean, ultimately, I guess you get down to questions about some level of taste, but it's taste measured against a pretty objective standard of what structures in that part of the community look like, what are the conventions, what are the forms, what are the materials, and you actually have a pretty good way of deciding appropriateness on that basis. So I think I'm gonna mute and others talk. I'm sorry that's so long. I see that John's on, so maybe John, if you want to comment or correct anything that I said, please do. And I'll go to mute now.
I'll leave it to the board to ask for my input.
I think what's interesting about like John's comments and what we've been struggling with for a long time is like, how do we get this, just kind of like big picture, like how do we get this code or process correct? Because I think we're all comfortable with the membership of the HPC. So what happens if we have completely different group of people and they start, getting carried away with the word aesthetics and, flagpoles and everything else. Like, and I feel like, this has been our challenge, Tom, right? Is like, we've really tried to anticipate, coming up with code where it should be agnostic, whether, our current HPC membership is there or it's, some new group. So John's looking at this with fresh eyes, and that's what jumps out at him. How do we get it so this code works, regardless of, who's on the HPC? right? I mean, is that, kind of big picture what you were saying, Chair Oleski?
Yes, I mean, look, my concern, obviously, again, I tried to be as clear in my letter as I could, Tom, and the rest of your commission. It's not about you guys, but this is a code that is for future boards and commissions, and for the village residents to live with in the future. And my concern is, first, that you kind of the good intentions here of which I understand, which is that how do we have design standards that go beyond kind of the cabined ones that are in the historic district, that are in the gateway district, that are in the NBR now, that are in the B1 district, but are not in the B2 district, that aren't in either of the residential districts? How do we kind of, have some kind of fair and objective system for controlling design and construction and improvement, in a way that allows the village to grow and modernize without being kind of a suburban sprawl free-for-all that none of us and none of our community, I think, wants. And I just struggle with, kind of, again, and I apologize that I was not aware of this. Whenever this discussion was had with Eve, I was not a part of that. And I feel bad that I have not, kind of taken the effort, but here I am. Is the best I can do is to jump in now. And it's really not so much a principled objection from me in terms of, certainly not the current board and what I think is going to happen, but I do worry about an Article 78 challenge and the village losing a lot of money in a legal challenge, in that I know that it's not the purpose of this to de facto declare the entire village a historic district. But I think from a legal perspective, I can't give the village legal advice, but I think it's a good idea for the village to go back to its lawyers in light of what I'm raising, maybe, and ask that question anew, because under the municipal law now and the village law, and what the HPCs writ large in the state are supposed to do is, they can designate landmarks, they can designate historic districts, and then there's this first level of protection for landowners under that, where if they're going to get landmarked or they're going to get put in a historic district, they get to have a public hearing at the outset about that first, before they're even subject to this kind of level of review by another board. And then there's a process for, okay, I've been put in a historic district, or I made a landmark, and now I know what the rules are for that, because this is the district. The board has made specific findings about this district and what needs to be in that district, or what's important about this landmark. And so I can expect that, I can't put up this kind of a sign or paint my house pink, or, if it's part of the Huguenot Street Historic District, for example. My concern is that what this in effect does, even if it's not saying it, is it says, well, as for everything else in the village, the HPC still has to approve in advance almost anything you change. And the exceptions that are in there are pretty limited. And I understand the intention is not to mess around with minor things, but the way I read the proposed code, it would mean anything you affix to the front of your house automatically, any window you change automatically, any front door you change automatically has to get this certificate of appropriateness. Any lighting you put on your front walk, for example, any sign you put in your yard. And unlike, so those landowners would not have the benefit of, the first stage of challenging, do I even belong in a district? Is my property even landmarkable? And the village is relieved of making the specific findings that are in the general municipal law about that. And instead of having kind of fairly specific and reliable and understandable metrics of what can I expect the HPC to be thinking about when they look at my request. If I live in Huguenot Street, I probably have a good idea of what that is. Living here on Prospect Street, what is HPC going to think is appropriate? The house I'm in now at 34 Prospect Street was built in 1986. There are houses up the street that are from 1920. What is HPC going to hold my landlord here to in terms of wanting to put up a fence? And I understand that the current membership doesn't think that aesthetics is an appropriate really judgment for them, but the way this code reads, there's really not much else besides aesthetics. in the proposed code to go on. It's, does it, and I appreciate the idea is what we're looking for is just as a, safeguard that you're not going to degrade significantly the property. But if you look at the code proposed revision, really what it requires HPC to do is make an affirmative finding that they're sure, basically, that it's not going to substantially affect negatively the property. And again, it's not about the current board, but I am worried about some theoretical future board deciding, hey, look, you know what? We don't think that inexpensive wooden picket fences are attractive and are a historically appropriate part of this neighborhood. And so we only want wrought iron fences. Even though the village code doesn't say anything other than no chicken wire right now, which is the kind of objective standard I think, is not susceptible to an Article 78 challenge. I think we risk the future of a HPC saying, we don't like you painting your garage pink for this neighbor, but not for that neighbor, and the law getting struck down over decisions like that. So that's my issue with the kind of the mechanism here for expanding what is, I think, going to be seen by the courts, but you have to ask the village's lawyers what they think, as extending beyond specifically determined landmarks or districts that we find this about their historic character. We need to preserve that about, development in the future too. Everything in the district is important to maintain historical character for, and it's going to be on a case-by-case basis, by the HPC, and under the code, there's really not much besides aesthetics or, the character of the neighborhood, which is, I think, a tough thing to make someone go through an application process for over hanging a flag, putting up a fence, planting a tree, lighting a walkway, which I think right now it covers. Now, I think maybe it could be restricted to cover much less and avoid those problems. Or alternatively, from what I've seen from the cases in Michigan and Washington, if we want to designate the entire village as historic district or a series of historic districts, make the specific findings that say what the kind of historical considerations are and what kind of character we need to preserve and those kinds of things, so that landowners know what they're getting into if they're not going to get the benefit of objecting to being put in a district or getting a landmark designation. Again, this is not about what I think is right or wrong. It's just risk management. It's just risks that I see that I think it's appropriate for the village to ask its lawyers about. Same thing with the supermajority thing. Just the way I read the state law is that the legislature can impose supermajority requirements on the village board to approve site plans or subdivision plats, but that the village board cannot impose additional supermajority requirements for specific kinds of applications, or in light of the HPC or say the EPB or the Shade Tree Commission recommending one thing or another thing. So I'm sorry if that was so long and I rambled on, but
No, that was great, John, and we really appreciate it. First, I just want to make sure and I think I speak for my peers, we're nowhere near ready to vote on this. We want to do a ton of more talking about it and hearing from people about it. And I think your fresh eyes, like Tim says, is like validation of that we do need to do that, right? Because you just
and if that's the case, I definitely also want to bring in the rest of the planning board too.
Right, and legally we need to loop you in, so there's that as well, and we don't want to wait till the end of the process to do that either. And I think you characterized well the intention as well as the pitfalls that we don't want to fall into. I mean, I'm still I always say, like, consistent with existing architectural style. I'm still like that. I really wrestle with that because it has an embedded preference for the status quo, and that's just one of the lenses that I'm viewing through this as well, which is sort of related to some of your feedback. And all communities wrestle with what is community character when as defined by seeker, right? And just this idea of the character of a neighborhood, I really appreciate how you articulated the subjectivity of that and the different biases that come in, because we do want to make this, all of us in this process, the village board and the HPC, want to make this as objective as possible. And it's a heavy lift in this instance. But I also think that we have broad community support for addressing the problem. We just want to make sure we have the right solution. So thank you for your comments.
Yeah, and John, I would just add, I also appreciate them, and I regret that, I don't know, the timing was peculiar. You know, this document was created before you were chair, and I think even on the planning board. I'm not sure of the chronology.
I think I was there, but I think it was during a period where I think Eve was largely winding up her chair work, and I think she was focused on the other code revisions, proposed code revisions, for you know, lowering the standard for some of the site plan approvals. I forget the code number for that. So I was aware of that. I just, and it could be that Eve did raise it with me, but it just got lost, at least in my shuffle. And so unfortunately, this is the first I'm picking back up on it.
Yeah, no, absolutely. And, you know, just to help you a little with the chronology, I think we first presented the code revision suggestions in February. And then April 1st, we had a Skype meeting or a Zoom meeting. And here we are 5 weeks later. So, you know, in terms of timing, it couldn't be worse vis-a-vis COVID, because we haven't really had a chance to meet face to face or to do this in a more productive way. So John, I just wanted to say, you know, I too want this to be right. I too have a general concern about future HPCs, just as I would about future village boards and planning boards, right? I mean, they're ultimately made out of people, and people are different, and there are always biases and emphases. So we want to get it right. Maybe we could just productively talk for a second about one of the things that KT raised and you raised, and it has to do with this idea of aesthetics. And I just want to emphasize again that we're not working out of an abstraction. There's a document called the Secretary of Interior's Standards for Rehabilitation. Camilla's holding it up. And this is kind of the playbook for every HPC that's doing due diligence and playing by the best practices, in which you actually have enumerated standards about what is and isn't historically appropriate. So, you know, while it, I suppose, can look that way, that, you know, this fence or that fence is appropriate or not appropriate, it's not coming out of a place of just sort of aesthetic preference. We are asked to compare forms and materials and shapes and setbacks, and everything exists in a place. And I think we all know what happens when that doesn't get followed, right? You get this mishmash of styles and setbacks, some car, you know, some driveways in front, some driveways in back, and pretty soon, you know, one of the principles I've always emphasized is very little of this happens by bulldozer. You know, it happens house by house, extension by extension, project by project, and it's very slow, tedious work to keep up with it. But when you step back and see some of the results of it, you know, all of a sudden a neighborhood or community is destroyed. And if you haven't had a chance to see the video that we put out a couple of years ago, there's a couple minute sequence in there where we kind of illustrate what happens when nobody's watching this stuff, and you get sort of windows filled in and just sort of blocked in, you get mismatched windows, etc.
You get 51 Main Street.
Well, yeah, I mean, that's kind of another, yeah. I mean, KT, I think, alluded to this, that there is a lot of interest in the community in getting something in place. So, you know, we talk about new construction, and we also have to talk about renovation, small and large. So I'll pause. I'd really love to hear from
Yeah, do we want to just, for the sake of what we have on this agenda, so we have that letter of support from the HPC, you want to, someone want to highlight what was included in that letter?
I could read it. This one's shorter.
That was the town's HPC, just to clarify, right?
Yeah, this is from the Town of New Paltz Historic Preservation Commission to the Village Board of Trustees. Subject: local law amending section chapter 86 of the New Paltz Village Code. The Town Historic Preservation Commission enthusiastically endorses the amendments to the Village Code being proposed by the Village Historic Preservation Commission, including the certificate of appropriateness as part of the building permit process will significantly improve the oversight of changes to existing properties, as well as new construction that could impact the historic integrity of the village. Sincerely, John, the other John, Chair of the Town New Paltz Historic Preservation Commission. And it's on letterhead. Thank you for those comments.
Does anyone else on the HPC want to, share any thoughts on, the discussion so far?
Maybe I would like to say that I don't think the intent here is to declare the whole village as a historic district. And I don't think that in the code revisions that have been proposed so far, it's been put forth as such. And there is a differentiation. If you look at section 921C, it specifies non-landmark, non-historic district properties. So it's certainly not a case of everything in the village being declared as a historic property. And I think we just would like to promote best standards or best practices that can be applied to both historic buildings and non-historic buildings when it comes to renovations or new construction.
Right. And again, it is not my intention at all to suggest that anyone here is intending some kind of impropriety or power grab or
Sure.
or anything like that. My concern is more that that what this is doing is that it's using the powers the village has under the general municipal law to impose certain requirements when the village says, oh, this is a historic district because of these reasons, and we'll make these specific findings. This is a landmark because of these reasons, we'll make these findings. And then the law has these kind of procedural things, hoops we have to jump through, and that the landowners get to object at that stage before they're even put into it. My concern is that by basically saying, well, we're just going to exercise that power over everything in the village, even if it's not in a district or not in a landmark, I'm just concerned, again, risk management, that the first person who's unhappy with a decision like that is going to bring it to court and will lose. That's my concern. But again, that's for the village's lawyers. It's not about me thinking there's bad motives or me having any objection to the overall, objective, which I think we're all on the same page of what we want to try to achieve. It's just about, again, for me, risk management and making sure we do it procedurally in a way that's going to stand up and not, cause us problems down the road. That's all.
Do you think that if it wasn't the Historic Preservation Commission that would look at the applications or look at design standards, but some other commission, would that be an issue then? Is the problem, does the problem lie with the fact that that is the Historic Preservation Commission, and so it gives the impression that we are looking at it strictly with the same standards as we would look at historic buildings? I mean, I don't know.
I think the problem is that, or the concern I have is that in the case of a historic district or a landmark where the village has had to make specific findings about what it is and what they're trying to preserve, that gives guidance to the people who live there or own the property as to what the boundaries are, and that kind of gives guidance, explicit, objective guidance to the board that's deciding it. I think any board that's given that power, if there isn't an objective criteria, but rather, and I appreciate Tom's point about that the board is not trying to impose its aesthetic will on people. The problem is that the code as it's written now talks a lot about aesthetic improvement or detraction. And in the absence of specific findings about a historic district or a landmark or some other objective findings, like for example, the village has a law, no chicken wire. No one can have chicken wire. That's not a judgment call by any board. The village has made that the rule for everybody. The problem is having a board that gets to decide on a case-by-case basis, we think this fits. We don't like this here, without having any objective standards.
But John, right, like two things though. We were very aware of not wanting to create design standards because then you would need a book that's like 4 inches thick. And then the other thing that we were very aware of was we understand that there are significant reasons why you want to be careful when you use the word historic. It has very specific, triggers. So, early versions of this draft law used the word historic very differently, and we scaled it back, and that's why it's written the way it is. And I think we're being very careful about not saying that this is being looked at through a historic lens, even though it's going to be work done by the HPC. Like, we were very careful to use that word historic responsibly in this version of the code that you're seeing.
Right. I guess my concern is that once you detach yourself from the authority under the general municipal law for the village to protect historic structures or historic districts or historic landmarks of special significance, where the village is supposed to be making special findings about these special places, then at least from the situations I've seen where, for example, the state of Michigan tried to declare all of Ann Arbor, Michigan, basically protected under their similar law. And it failed. And so my concern is that I hear that the kind of catch-22 here, which is that the alternative is having to come up with some kind of objective set of criteria. I wonder whether or not there is a medium ground, which isn't just kind of saying it's important for us to have historically consistent and appropriate kind of design standards for our village, and leave it at that, and then leave it to the HPC, and instead make some kind of more specific findings along the lines of the ones that were made for the Huguenot Street District, or even for NBR, or even for the B1 district. The B1 district on Main Street, has the standards about, if you're repurposing a residential building, it has to continue to look like that. Those kinds of things. I don't know. Again, my concern is just that what I see the authority the village is drawing on is that general municipal law authority, which is very grounded in these specific, findings about districts and landmarks and the procedural safeguards for the landowners, that kind of de facto the village is saying the people outside those districts kind of now have less protection and don't have the opportunity to object to being subject to this the way that people and in some ways now, why would the village ever declare a landmark or a historic district, and give people the chance to fight it out at a public hearing that they belong in a historic district or that they belong in a landmark building, if for all intents and purposes the HPC is going to have pretty much the same power to deny a certificate of appropriateness for any property in the village. These are my concerns.
Yeah, no, that's, if I could just speak to that, John. So this process has been rolling along for probably about 3 years. And one of the really significant decisions we had to make along the way was whether to basically make it village-wide, which is what we ended up with, or to basically piggyback local jurisdiction on the currently designated Main Street District, which is a state and national register district. This isn't widely known, but for a decade, Main Street has been judged by the state and by the nation to be historically significant. So it seemed like, you know, at one point, a pretty easy move to say, well, if it's good enough for the state and good enough for the nation, we ought to have some local oversight. Because ironically or strangely, when you become a national or state registered district, you don't, it says nothing. It's absolutely neutral on local preservation. And so, you know, one of the things that we could talk about, possibly revisit, is going back to the obvious historic core of the community and leaving the other neighborhoods out. Tim and I had long talks about that before this language even got drafted, and he felt strongly that village-wide was the way to go, with the understanding that large parts of the village, you know, just aren't subject to the kind of historical oversight that parts of Main Street would be. So I think that's just kind of important to keep in mind, that we had a moment, you know, more than a year ago, well over a year ago, when that was really being discussed as, you know, what's the best way forward. And I think there's some advantages to extending out to the community at large. You mentioned you live on Prospect, I live on Grove. There's a kind of notorious case on Grove Street where, you know, a really nice 20s era cottage tripled in size. No thought was given to what it was sided with. So you've got a house with two completely different materials. And one of them is a big rectangle with a huge parking lot attached to it. And it basically destroyed a house that I don't know if it ever would have risen to individual landmarking, but had a historic and you know, neighborhood integrity that's gone. I mean, it's gone. To me, that's kind of for Tim's point, that the, you know, people who don't live in the most historic parts of the village also have some rights to live in a community that's consistent with the community.
And I believe me, I live around the corner from that house. I know exactly what you're talking about. And so, I mean, I understand. My concern again is with making something that's going to stick for the future and is not going to kind of turn against us. You know, again, you know, my house, again, I don't own this house. My landlord neighbors do. But this house was built in 1986. And so it's tough for me to figure out, you know, let's just say they wanted to put in some improvement in the front yard, or some alteration to the front of the house, or they wanted to reside the siding of the house. And while I could understand that right now, someone like you and the current membership would, you know, this would not be an issue for them in terms of this is not one of the village's historic, you know, treasures. And if the homeowners decided to side it with a slightly different shade of gray, probably not an issue. The concern I have is that the way the law is drafted right now, some future HPC members who, you know, for whatever reason, just don't like the look of whatever is proposed, would probably be able to deny the certificate, and they wouldn't be basing it on some kind of historic judgment, because there really isn't one. The only thing that's left in this proposed code for them to judge it on is it detracting from the aesthetics of the building. And so, for example, if enough neighbors complained and didn't want this yard to be fenced, or didn't want it to be fenced with a particular material or in a particular way, under this code, it seems like the HPC would be required almost to withhold the certificate. And I know that's not the intention here at all. But my concern is either that kind of, you know, bad outcome happens down the road, or I think more likely, someone wants to do something that really maybe isn't something that's in the historical character, that something is, you know, that we as a village and as policymakers, you on the village board really want to try to stop. And we're not going to stop it because they're going to successfully challenge the process, just because of these process objections to overextending the village's power under the general municipal law. That's, again, I think we're completely on the same page in terms of what we're looking to do and accomplish here. I'm just trying to hopefully, I hate to be coming in so late, and I hate to be like, wow, I'm crashing your party and raining on your parade after you've worked so hard for years on this. But I really just feel like it's, to the extent that I'm being a Cassandra about it, I'm happy to have the village's attorneys say, John's wrong, don't worry about it. But I really do think, to the extent that it hasn't been looked at again more recently with this language that I saw today, that it's worth doing that. That's all I'm trying to throw up a flag for.
And John, I appreciate the what if scenarios that you're talking about, but I think what we've struggled with as folks living in this community is like having no process, having no review process whatsoever. We end up with as my kids put it, they say on my phone, I got pictures of them and then pictures of buildings that make me mad. So we need some sort of process, some sort of review process.
I agree completely.
And we've gone over this many times, and with developers and with property owners, and Tom and other members of the board have had these conversations. And the way I frame this is like, it's almost like free consulting. Like if you have an idea where you want to, put in a window or a front door, and I know I need a new front door, but I don't know what door would be appropriate. Wait, I get to go to this board where there's a bunch of people who love understanding the difference between doors, and they're going to give me free advice and tell me that this is the kind of door that would work best with your style house.
I think you are overestimating how many people. Yeah, but I think you're vastly overestimating how excited people are going to be about filling out an application. I'm not,
because I'm basing that comment on the numerous conversations that we've had with developers who, like, they have an idea, they want to build X, and like the details they don't necessarily understand or have thought about, and they want to do something that the community appreciates. No one wants to construct that building that pisses people off.
I agree with you. If in terms of developers, I'm talking about, like, though, if my landlord wants to replace the front windows here, I don't think they want to have to apply to a board and wait to see if a public hearing is going to be required before they can replace their windows.
No one wants to go before the planning board ever. No one wants to go to the dentist.
But no one has to go to any board right now to replace their windows. Right. And so that's what I'm just saying, I'm not sure everyone's going to see it as a favor. And I think that some people in this town or in this village are going to be motivated to challenge what they view as the village board telling them what to do with their front door. And I think I'm afraid of the village losing that challenge. That's all I'm afraid of.
Yeah. John, I'm convinced that you're right, that, there will be people who under any circumstances don't want to be told. I mean, this is very tricky stuff sociologically and psychologically, to be told that the property that you own can't do everything that you want to do. But I think we all know that already exists, right? I mean, you mentioned fences earlier. You can't put up a 20-foot fence in this village, even though it's your house. I mean, we've got all kinds of...
That's true, but right now, as long as the fence isn't chicken wire, and as long as it's 4 feet in the front and 6 feet around the sides and the back, I can put up a fence. And I don't have to ask anyone's permission, and I don't have to get a building permit, and I don't have to wait for anyone's approval. I can just go to Home Depot or Lowe's or wherever I choose and buy my fence and erect it. And I'm allowed to do that right now. And what this would mean is that I can't anymore. And the warning I'm trying to raise is that I think there are going to be people in this village who are going to be very angry about that. And they are going to want to take the village to court over it. And my concern is that...
Alex wanted to say something. Let's give Alex a chance.
Oh, no, I was just wondering what that Michigan case was. Was that like the one that was like drip drop versus Ann Arbor, or do you know off the top of your head?
It was Ann Arbor, so I'm not sure of that. Yeah, there was that one, and there's one in Washington State as well. Both where kind of basically the state declared the entire city or town to be a historic district without kind of making specific findings. And the court said, well, if you had gone through the process of, laying out the objective criteria that made this historic and made it special, and what you were trying to preserve, and what the landowners needed to know about what they could do and couldn't do and could expect in the process, then maybe it would be okay. And again, that's all my concern is here, is having someone pick the fight with the village board over this and win. That's all.
Yeah, that was a really good example. I don't think it was drip drop, but like something similar to that v Ann Arbor. I think really like does a good job of like exploring all these different like what ifs. If I come across it again, I'll share it with everyone.
I think it's really good, Alex. And one of the takeaways I'm sort of feeling from tonight's discussion is, we did have initial assurances from the village attorney that this is all legally sound, but I never heard that Ann Arbor case mentioned. It didn't come up. And so I think a takeaway for me is, we perhaps should ask a new set of questions about the legality of what we're suggesting here. Because nobody wants a lawsuit. As a matter of fact, I don't even want contentious HPC meetings. I don't want that. And I don't want to visit that on future commissions or future boards. But I think we do all seem to agree that, we have a problem and it's nobody's fault. There aren't any villains here, but the planning board has a lot of work to do, and they're not specifically charged with anything having to do with historic character. So you actually don't have, in the current state of things, you do not have adequate reasons for rejecting an architecturally inappropriate project. You have to say yes if it meets building code and
oh no, that's not true, because we are able to rely, in fact, we are required by law to refer to the 1994 comprehensive plan and the 1997 gateway zoning documents. And the way I read state law, we're also supposed to be looking at the NBR policy materials and the B1 policy materials. And so at least, my perspective as village planning board chair is that, when someone comes before us and the question is, does this fit with the character of the community? We're supposed to be judging that according to this kind of group of documents that together constitutes the up-to-date comprehensive plan of the village, which to me does incorporate a lot of these kind of historic preservation policy kind of decisions that the village has taken and expressed over time. I will acknowledge, this intersects with my interest in maybe somewhat formalizing those updates, to help us with that. But I do think that we have the power, as it were, to make sure that applications don't fall afoul and aren't just like kind of like new McMansion in the middle of Prospect Street. I do think we have that power. The issue, I think, is that it's not really laid out very clearly. I'm not sure every planning board would think the same way I would, because I don't know that the guidance is that clear. And I'm not sure how safe decisions that we as a planning board make on that basis are, given that the comprehensive plan, the original one, is old, and that the subsequent documents are kind of fragmentary. So I agree with you completely in that I don't think that what we have is satisfactory. I think we do have that power, and I think we are supposed to try to conform to, we're not supposed to be blind to the fact that the village put an HPC in place, and that the HPC has expressed its views many times, and we've gotten your input when under situations now where site plan review requires your input. But I agree with you totally. I think that we need more and better, and I do think that there's a way for this process to work to do that. I'm all about just trying to make sure it stands up in court. It's not about me not wanting to get to the same endpoint as I think everyone else in the room.
And I guess that, I would love some people's thoughts on this. I think going back to Will Frank with this set of questions, specifically asking, are we making ourselves vulnerable with changes like this? it would be a good idea.
Hey, John, and help me understand how this would work in the legal world. So as the code is currently written, let's say this HPC review board says that, I need a door that's this design, but I just want to build, put in whatever door I want. So I could escalate it and pursue legal action against the HPC. Couldn't the HPC or the village just be like, okay, whatever, just put in the door you want?
Well, actually, no. I mean, the vulnerability here to someone who wants to pick the fight is that the way the law is written now, and this is what I think is going to be a very unpleasant surprise to some of our neighbors, I think, maybe in a way that people had not fully appreciated. But right now, the way I read this is this goes into effect, and then suddenly everyone who wants to change their windows, their door, their front sidewalk, putting up a fence, anyone plant a tree, anything more than a bush, is required to make an application. Now, the law says there's no fee for the application, but under my understanding, again, I can't give legal advice here, but my understanding is that it doesn't matter if there's no fee. The having to make an application and get a permit or get this certificate and wait the up to 62 days that HPC is allowed to take to decide whether to have a public hearing about it is itself enough of a potential constitutional violation that someone could go with an Article 78 to Supreme Court without even giving the village and the HPC the chance to say, we don't care. Just the fact that I want to change my front door from black to red. You say I have to get an application? No, I don't. I'm going to court to overturn this law that says I need an application. And I think there may be people in this village who are motivated to do that. Because I think they're going to be very unpleasantly surprised to find out that these things that previously there had been absolutely no prior review of is now something that is subject to, you can't start doing that until you fill out this paperwork and file it at Village Hall and wait to see what the HPC says. And if your windows are drafty, too bad. Wait.
Okay, so why don't we, do you guys want to, maybe we can just get a call together with our attorney, Will Frank, and have some of this discussion with Will and see what he says, because, we've, to Tom's point, we've been discussing this for some time, and we felt like we smoothed out a lot of rough edges. But let's see what Will says, and you can.
Yeah, I think you need to do that, because you cannot rely on my legal take. You just can't. So yeah,
but
absolutely.
It'd be good. Well, let's include you in that conversation.
I'm happy to. I'm happy to do anything I can.
I think that would be great. It'd be prudent. And John, have you been consistently saying that you are an attorney, but not offering legal advice in this context?
Yes, because I have a dispensation from the Joint Commission on Public Ethics, because I'm separately a public officer and policymaker for the Attorney General's office, and so I have a separate approval and a series of recusal requirements in the case of a conflict of interest. And as an attorney for the Attorney General's office, I am not allowed to offer legal advice to anybody other than my client, the Attorney General.
That's great. It's very helpful to know that. And
yeah,
great.
Like, didn't we need the Attorney General to offer an opinion as to whether we could put you on the planning board?
No, that was the Joint Commission of Public Ethics.
Got it. Okay.
What would really help, John? I don't think this is asking something that you can't do, but you'd mentioned that case in Washington.
I'm happy to provide the references to that stuff.
Sure. Have those citations, we can ask Will to look at those.
Sure.
Yeah. I wanted to assure you too that we've talked a lot about very minor things like window replacement. Even on Huguenot Street, we've got the ability to say if it's like for like. In other words, if you're putting in thermopane versions of what you had before that were drafty and leaky, we don't even have a hearing. We just, we have a dispensation for anything that's like for like replacement, and it's just done. We
Oh,
record.
I agree. It's totally reasonable. And the kind of safeguards you tried to build in here are totally reasonable in a world of reasonable people who, you know, are all on the same page. But my concern, and, you know, I will bring my bias from my legal experience into this, is that we don't live in a world of reasonable people. And even in this village, we don't have all reasonable neighbors, or even there may be people who are totally reasonable. And for whatever reason, in the particular circumstance, they just honestly believe that their rights are being infringed. And people are motivated to go to court when they feel that's happening. And I'm just concerned about you all spending a lot of time and potentially a lot of village money trying to do the right thing, and then just kind of, you know, tripping over it accidentally. And to the extent I can help avoid that, that's all I'm trying to do. That's all I'm trying to do.
I think it's hugely helpful. It really is.
Yeah, and I think this is exactly what we want to do, is be patient and have these workshop discussions. And, you know, if we can, you know, figure out improvements to this language, you know, based on what you've commented on, that would be great. And then someone else will come along and identify some other things that we could do to improve this concept. So, you know, we want to be patient and get this right. So this is great, and we really appreciate you taking the time to take a hard look.
I'm happy to help however I can help anytime.
Tim, what do you think a next step is? So we will sort of off to the side get back to Will Frank with a set of questions. What about the next opportunity for public input? I'm assuming nobody texted or chatted or whatever it would have been through YouTube, right? We had no input from the community.
I think I only saw comments. The only comments I saw posted were people I think who were involved in the process before. And I guess just from the peanut gallery here, you know, I didn't know, even though obviously this directly in some ways implicates the powers of the planning board. I didn't really know until I kind of was like, boy, I should really check out the village board meeting tonight and see what's going on. And, you know, I would suggest that to the extent that this process is going to continue to implicate the possibility that kind of workaday changes to residential properties that heretofore have not been in a historic district or landmarked, you know, where changes that people have been used to being able to make without asking any questions, to the extent that now people are going to find out after the fact, oh, wait a second, I'm supposed to now have to ask for permission for this. I would just suggest that that's something, you know, there, and especially given what's going on with the public emergency, I'm just concerned about, you know, notwithstanding kind of posting public notices on the village website, et cetera, about this still taking people very rudely by surprise and people being very angry about it, no matter whether or not, you know, kind of formally I's were dotted and T's were crossed in terms of having public hearings. If people don't show up for them, I don't think people are not showing up for this meeting because no one would care about being told what to do with the front of their house. I don't think people know that this is.
Yeah, we're 100% comfortable with the idea that this will take a long time.
Yeah.
And we're going to do a series of these. You know, we even committed to that before we were forced to live online. So we're fine with being patient and you know, having this conversation over and over and over again, and hoping that, you know, if the newspaper reports on it or Facebook complains about it, then that will attract more people to, you know, share their thoughts. Like, we get it, you know, this is the way we want to do this.
Yeah, I mean, I have to say it's a real shame, and I think it's going to be a real problem, not just for this, but writ large. The fact that Ulster Publishing is down and no one's getting paper copies of the paper anymore, because I know a lot of people, that's how people knew. And HV1 is not, you know, has a paywall in front of a lot of the local stuff now. So I think a lot of people are shut out from information flow that they had before about what's going on here, Woodstock, Kingston. It's a real problem.
Yeah, even if we had a slam dunk of a code chain, we're being incredibly careful not to make changes while we're, you know, trapped, you know, behind these laptops. So.
Do we want to think ahead to another session? Maybe a month out or something like that?
I'm fine with rounding up and saying, 4 to 5 weeks from now, because that's the idea, is like, next time, someone else will come by and share their thoughts. Like, that's what we're trying to do. In the interim, we'll have that conversation with Will, and we'll invite John to that conversation. And, this is, to your point earlier, like, and KT echoed this, like, the planning board is required to review any code changes anyways. Like, we're not even at the point where we're ready to show it. We would love planning board members to look at it on their own right now, but like, we're not even at the point where we're wanting the planning board to look at it in their formal capacity.
I agree, Tim. And John, one of the other things I could certainly offer is, if you want a brief, and I can promise brief presentation at the planning board, I'm happy to do that. I feel like I know every syllable of what we're doing here because it's been with me for so long.
Well, and honestly,
And,
we had no applications for
something that a long time ago.
Well, I mean, honestly, here's the thing is, we had no applications on deck last night. And so we canceled our meeting for last night. Right now, we've got no applications. But even if we do, it's going to be, I think, minimal for 2 weeks from now. So I think it makes sense. Why don't we, I'll get back to you. I'll talk to the rest of the planning board members, because I think we should talk anyway, just to let them know that this is like, potentially on deck being discussed, and get their thoughts on it. Because I don't want to be doing this in a vacuum. Kind of like, I worried that last time I was kind of, just incidentally siloed out, and I don't want that to happen to other members of the board. And yeah, it'd be great to just see if we can follow up maybe offline about having you come in and talk to the board, whether it's in 2 weeks or thereafter.
That sounds great. Happy to do it.
Okay, so you guys will work with Alana and get onto the upcoming planning board agenda. That sounds like a good idea. Do we want to schedule another one of these village board workshops on this topic? We could do like the middle of June.
That sounds good to me, Tim. If people are willing, I mean, I know you have other things to do and may have a lot more.
Are you thinking June 17th?
Is that the third?
It is.
The third Wednesday? Yeah, let's do that one.
John, do you happen to know when the planning board meeting is?
2 weeks from yesterday. So yesterday was the 5th. So the 9th, what is that? Yeah, the 19th.
I'll pencil that in, and I'll wait for you to formally invite me. Okay.
Great. Thank you.
Thanks to everybody. I really appreciate the input and the thinking. And Tim and I will get right on. I guess John and I will get on talking to Will.
Yeah, and why don't, for that June 17th meeting, why don't we even like frame it as, like initial unofficial feedback from the planning board, and then we can review how that conversation went, with the village board.
Yeah, I guess the only issue is, but I think our next meeting is not until the 19th
of May.
Of May. That's right.
Yeah.
You're talking about June 17th. Okay. Yeah, absolutely.
Yeah. So Ariana, when we go ahead and announce that we're doing this workshop, we could almost describe it as that, just to give it a little context. And then when we show up on June 17th, we'll know exactly what we'll be after, just in terms of like having a summary of that conversation. That just helps me.
Yeah, sounds good.
Okay, so I think we're done with this topic tonight. Can we move on to the village board agenda?
Tim, thank you so much for the time, everybody. Thank you very much. And I will spin off and go have some late dinner.
And likewise, if it's unless the village board wants me to stick around or has any other reasons why you think my input will be useful for you, I'll also check out if that's okay with you guys.
Well, you guys don't have to leave. We're going to actually consider going ahead and making an emergency purchase to replace some mechanicals that failed at our sewer plant. If you want to hang out for that.
I'm very interested in the sewer plant, actually, but I don't think I'm going to have any red flags for you on your emergency purchase plans. So, although and also I have to say, I mean, I'm not a huge fan of these Zoom meetings. That I usually call in even at work when I can, and I feel a little bit weird, kind of being able to see into people's houses, and it's kind of why I'm outside. But KT, I think the same builder built our houses. Because
what year was your house?
86, I think 85, 86, but
mine's 52.
52.
Mm-hmm.
Oh wow, just that your stairway and the way your stairway is built it's just like mine, although is yours a single family home?
Mm-hmm.
Okay, see, I'm half of a duplex. It's just a coincidence then. All right, guys. On that note, that completely irrelevant note, good luck with your sewer plant fix. Good luck, and look forward to the rest of the conversation. Bye, guys.
Thanks, everyone.
Thanks, everybody.
Thank you.
Thank you.
Thank you.
Bye. Okay, so I'd like to make a motion that we go ahead and purchase this item related to the rotating biological connector for the grit removal process at the sewer plant at the cost of $4,708.19. It says two quotes, but the quotes are for two different items. We need both of them.
Second.
All in favor?
Aye.
Any opposed? And then Will tightened up some process documents related to the sprinkler law that I believe we had to resubmit. Can that just be my motion that we go ahead and authorize me to move those, or do we need to do anything different, Ariana?
I don't actually know. I don't think I received anything about it. But I remember you talking about it. So I think we could just say moves to resubmit the sprinkler law documents from attorney Frank.
Yeah, it was mostly a process issue. So that Will just wanted to make sure that we had some I's dotted. So that's my motion that the village board authorizes me to go ahead and move that forward.
Second.
All in favor?
Aye.
Any opposed? And then I'm going to just do the resolution regarding bills and claims right now. I motion that we move bills and claims.
Second.
All in favor?
Aye.
Any opposed? Okay. For items 3 and 4, you know what? Yeah, let's go into exec session to discuss both of those, and then we'll come out of exec and decide what action. So I sent you guys all a Google Meet invite on your phones. Maybe we can just like shut off our mics on this Zoom call, and then
do it on our phones.
Do it on our phones.
Smart.
Okay.
Tim and Michelle, you should also stop your video.
Ari, are you there? I have a question.
Yeah.
So it's telling me to get the Google Meet app. Does that make sense?
It does make sense.
Okay, so I don't have that on my phone, so I might be a minute.
You could also call in if that's easier for you. There should be a dial.
That's a good idea. Maybe I'll do that. Thanks.
Yeah, of course.
I always feel like Mystery, like Science Theater 3000, like when they're like, and we're back.
Except Michelle is now outside and it's sunny.
And her hair is perfect.
And she's frozen.
Well, at least Bill's not the Tin Man from Wizard of Oz like he was those last couple of meetings.
I can hear you.
Hi.
Where's your Tin Man picture?
I have no idea. And I still have no idea how that appeared.
I like that Tin Man picture. I thought that was really cool.
Thank you. Totally unintentional.
Well, then I'm glad it wasn't something else.
Me too.
Okay, so Ari, are you back with us?
Yeah. Oh, yeah, I'm here.
Okay, so I'd like to make a motion that all proposed raises for non-union staff that were included in our fiscal year 2021 budget be put on hold due to the pandemic. And then our board will consider changing that or reevaluating that in December of 2020. So these raises were to go into effect June 1 per the 2021 budget. And I would also include that there were no budgeted raises for any of the elected officials in this budget. So we're not doing anything in terms of changing the elected officials' raises because none were planned. So this would only have to do with the non-union staff. So that's my motion.
Second.
All in favor?
Aye.
Any opposed? And then my next motion is I'm looking for authorization from the village board for the mayor to send letters to parking enforcement and traffic staff, informing them of their positions being eliminated due to the pandemic that we're experiencing. So this would include 1 full-time parking enforcement officer and 2 part-time parking enforcement officers, and then a traffic person who had been working part-time. So my motion is to have the board authorize sending that I send those letters.
Second.
Someone want to make a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? And that would be effective this Friday. I believe the date on Friday would be May 8th. Okay, I think that's it for this agenda. Oh, and the point, you know, it's important then when these staff end up with the with this letter about being laid off by the village, then they can go ahead and take that to unemployment and to pursue unemployment compensation.
I guess I just want to say nobody likes to do this. These are decisions. Obviously, we wanted things to go a different way. That's why we passed the budget that we did on both points. And it is important to note, as Tim said, that now given unemployment insurance and Alex, what's PUA? That's the supplement from the federal government, right?
Yeah, it's the pandemic unemployment assistance.
Right. That in all likelihood, wages will stay the same, if not be more currently.
Right. Okay. So we don't have anything else on this evening's agenda. So I motion that we adjourn.
Second.
All in favor?
Um,
Okay. Good night.
All right. Thank you.